Hi everyone, welcome to part 2 of our discussion of the sale of goods. In this video, we'll consider some of the key implied terms in a sale of goods and their implications for commercial transactions. In discussing terms, the first thing to do is to clarify the distinction between a condition and a warranty. You'll probably already have looked at this in contracts, but to reiterate, a condition is a term that is vital to the existence of the contract. A breach of a condition gives the innocent party a right to repudiate. Conversely, a warranty is a non-essential term of the contract, where a breach only gives the innocent party a right to damages. There's no right to repudiate. This distinction is potentially very important if a term is breached, and it will depend on the facts. In practice, most commercial contracts will specify which terms are conditions and which are warranties, but in the absence of such clarity, it's important that you can draw on the surrounding circumstances and dealings between the parties to identify whether a particular term is likely to be a condition or a warranty. The Sale of Goods Act provides a wide range of implied terms into a contract for the sale of goods. I won't go over them all here. Your study guide and textbook provide good overviews. Instead, I'll cover some of the main ones and their implications for commercial law. First, it's implied that the seller enjoys title, quiet possession, and no encumbrance over the goods. In other words, the buyer need not worry about the creditors of the seller coming after the good after the sale. The rise of the Personal Property Security Register has arguably reduced the need for these implied terms, but they still offer some protection for buyers, which is good. Next, it's implied that goods will correspond with their description. This is especially important in the sale of unascertained goods, as the buyer has no opportunity to check the goods for themselves. Another implied term is that the goods will be of merchantable quality. This implied term only applies to sales by description, although the courts have interpreted this quite broadly. Whether a good is of merchantable quality is context dependent. A wrecked car is not of merchantable quality as a car, but it might be of merchantable quality as scrap metal. If a buyer makes known their purpose for buying a good, and they rely on a seller's particular skill and judgment in choosing the good, there is an implied condition that the goods will be fit for that purpose. The onus is on the buyer to establish purpose and reliance, but when they do, this can offer a powerful protection against defective goods. Finally, when the contract is a sale by sample, it's implied that the supplied goods will correspond with that sample. It is possible to expressly exclude these implied terms from the sales contract, and this is an important difference between the Australian consumer law protections, which cannot be excluded. That takes us to the end of this brief video. We'll see you in part 3 to talk about breaches of contract and their remedies.